People of the State of Michigan versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the two files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the two open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
That was his very first misstep. And believe me, it's a huge one. What you're about to witness is someone attempting to represent themselves while constantly complaining about the challenges of doing exactly that. It's like diving headfirst into a pool and then yelling about getting wet. He craves the prestige of being his own advocate but isn't willing to shoulder any of the responsibility that comes with it. And in this courtroom, that approach is about to collide head-on with reality. Attempting self-representation without preparation is never just risky. It's a recipe for frustration and embarrassment.
407. Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or inadequate law books. They're old.
And we're off. Barely a minute into representing himself. And he's already demanding that all charges be dismissed under the Speedy Trial Act. His reasoning. He claims he didn't have enough time to consult some old law books, just a whole 90 minutes in the county jail library, apparently. Think about that for a second. 90 minutes of reading, and he believes he can outsmart a seasoned prosecution team. His entire defense rests on what amounts to Google-level knowledge, without any real grasp of legal nuance or courtroom procedure. This courtroom is about to show him, in no uncertain terms, that studying the law and actually understanding the law are two entirely different things. And one mistake here could cost him dearly.
And a half of studying, so out of my freedom of speech and the rules of professional conduct, I'd like to read my motions.
All right, go right ahead.
For every waste of time and the money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury and adequate time.
The judge delivers a swift reality check, and it lands hard. What did he expect? 8 years to go out and earn a law degree before stepping into this courtroom. Then comes the punchline that leaves no room for argument. You have the constitutional right to represent yourself. And you also have the right to make questionable choices. It's a harsh truth, but a fair one. Just because the law allows something doesn't mean it's wise to do it. And in this courtroom, that principle is about to unfold right before everyone's eyes. Confidence might get you attention, but it won't substitute for preparation, understanding, or strategy. In the end, bravado alone doesn't carry a case. Facts, knowledge, and proper procedure do.
Finally didn't explain what or help me, which is repugnant and biased by the court. And for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions making sure my rights were protected. And Rules 4.3, if they know the law and what I'm saying, these are U.S. Supreme Court, Michigan rules, and 30 days minimum for U.S. Supreme Court 3161-C2, Dismissal Speedy Trial Act 3162 and 3164, 1974, 18, and discipline of all attorney 3161, knowing I'd never be able to proceed without justification. Rules 3.2, repugnant or imprudent, prejudicing, impartial trial, miscarriage. Also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear.
Do you spot the contradiction yet? He's shouting that his right to a speedy trial has been violated, yet every excuse he presents would have actually required postponing the very trial he's demanding to accelerate. It's like insisting on fast food while asking the chef to slow cook it for 8 hours. He wants it all. Speed, fairness, and patience, wrapped up in a neat package, all while expecting the court to bend to his convenience. This is a textbook example of how some defendants confuse legal rights with personal preferences. Rights come with responsibilities and practical limits, and ignoring that distinction can quickly turn a courtroom into a stage for self-inflicted frustration.
People that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
Your Honor, that's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here. inasmuch as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez?
Unbelievable. It just never stops with this defendant. First, he demands a speedy trial, insisting the process move faster. Then, when the opportunity actually arrives, he doesn't even show up. That's not enforcing a speedy trial. That's inviting self-sabotage. Missing your own hearing essentially forfeits your ability to later complain about any delays. Of course, the law around speedy trials can get nuanced, and judges sometimes allow exceptions. But when the delay is caused entirely by your own absence, there's no room for excuses. This is a textbook example of tripping over your own argument, a case where trying to manipulate the system backfires spectacularly and highlights the importance of showing up, literally and figuratively, to defend your rights.
You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything
you gave me
wish,
bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So
That's
there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. In regard to your outstanding cases, the 237407ST, we will set that for trial on July 10th. That'll be all-day trial. That one will come first. And we will set the 226707ST trial for just for a call that day. But we're going to try the newer one first. The older one, he's already failed to appear on it twice. I'm making the following findings in respect concerning Michigan Court Rule 6.004, speedy trial. In regard to the matter concerning Mr. Martinez, bond is set at 1,000 personal recognizance. Actually, it's set at 1,000 personal recognizance in 237407ST. I don't think I'm going to set that one first then. In regard to the 226707, he has a bond on the failures to appear. He's already been sentenced on those. He's serving time on them now. The underlying bond on the driving charge is, can you pull it up on JIS, please?
On to the failures or to the underlying, it's 2,500 cash or 10%.
All right, we'll set that one for trial first then.
Which one?
The 226707ST. The newer one has a PR bond on it. so there's no requirements for time on that.
Okay, so there'll be a firm trial date on
July 10th.
7/07.
Yes, on July 10th. And concerning the matter then, in regard to the court rule, Mr. Martinez has been incarcerated since his arrest on May 25th on all of these matters that were outstanding. The trial is set for July the 10th, which is beyond 28 days. However, at this point in time, Mr. Martinez is, one, serving a sentence, two, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, and he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July.
Fines aren't the same as optional suggestions. They're court-ordered obligations. When a judge tells you to pay and you simply refuse, you'd better have an airtight reason. Otherwise, you're not making a statement. You're demonstrating contempt for the court. Keep ignoring it, and the next legal argument won't take place in a courtroom. It could very well happen behind bars. That reality check says it all. The judge is no longer entertaining games, and this defendant is quickly running out of options to dodge the consequences of his own choices. Courtroom patience has limits, and once crossed, the system has no problem enforcing its authority.
Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you. In the meantime, an appeal to circuit court may be taken within 21 days from the date of your sentence, or as permitted pursuant to Michigan Court Rule 6.625B, if the sentence includes incarceration, and if you wish to file an appeal but are financially unable to do so, MIDC will appoint a lawyer for you if that request is made within 14 days after your sentencing. In regard to the issue of trial, I request for jury instructions and whatnot. The pretrial order was released. I sent out a pretrial order last year. Those 10 deadlines remain in place. Mr. Martinez, we'll see you for trial July the 10th.
Yep.
Anything changes in the meantime, you know what to do. Yes, the balance due remains outstanding, payable commencing 30 days after his release from jail and every 30th day thereafter.
All right, everyone, that's a wrap on today's courtroom chaos. I'm still on the move across Europe, currently soaking in the sights of Prague, with Bratislava up next. Who knows where the next story will take us, but one thing's certain. The legal misadventures never disappoint. If you enjoyed watching this whirlwind of courtroom drama unfold, hit that like button. If it wasn't your cup of tea, a dislike still tells the algorithm you stuck around until the end. Either way, your engagement helps me keep bringing you these breakdowns of courtroom madness and sovereign citizen logic gone completely off the rails. Don't forget to leave a comment with your thoughts and subscribe with notifications turned on, so you never miss another deep dive into legal chaos, absurd arguments, and the lessons we can all learn from them.